If you get arrested for DUI in Georgia, one of the biggest decisions you'll have to make happens in a matter of seconds. And that's whether or not you take the blood, breath, or urine test, or if you refuse it. And there's really not a perfect answer for that. Let me explain why. After you're arrested, the officer will read what's called the implied consent notice. And after he reads that's the moment you have to decide your next step. Will you take the test? And most people have no idea what they're agreeing to or what they're refusing. So let's talk about what happens if you refuse the test. If you refuse the state-administered breath or blood or urine test in Georgia, your license can be suspended for 12 months. And if that happens, there's no limited permit. That means no driving to work, no driving your kids, nothing. That's an immediate consequence if you refuse that test. And in some of these tests, that can be used against you when you go to court, if you have a trial. If you take the test and you're over the legal limit, then that will be used against you in court, obviously. And it gives the state even more evidence and something concrete to point to argue in front of the judge or the jury. But it may also open up some areas to challenge the test and the case itself. So there's another area to concern yourself with about that. There's no safe choice here. This is where people get frustrated. It's not a simple answer, and they want a simple answer. Refusal protects you from giving a certain number, whether it's above the legal limit of 0.08 or not, but it also can hurt you on your license issue. Taking the test may help your license situation, but may ultimately hurt your case when you go to court. So there's a trade-off either way. So what actually matters? Well, the right decision really depends on your driving history, whether this is a first DUI, arrest, the facts of the stop. Did you do other tests like the HGN or the walk and turn or the one leg stand? What evidence is already out there? This is why a one size fits all usually doesn't work. And here's the part most people miss. Even after that decision is made, you still have a 30-day window to take action on your license. And this is one of the biggest mistakes I see people make. They focus on the arrest and they ignore the deadline. So if you refuse the test, you're giving a 1205 form. And it tells you that your license is going to be suspended if you do not file an appeal or get an ignition interlock device within 30 days. Okay, so you're given this form. If you refuse, within 30 days, you must file the appeal, the administrative license suspension appeal, or you must get an ignition interlock device installed in your car. Now, only certain people can do the ignition interlock. So you need to talk to an attorney about that to see if you're eligible to get that. Otherwise, you must file the appeal. If you don't file the appeal, then your license will be automatically suspended administratively for 1 year. And that's where people get in trouble because there's no limited work permit, anything like that. There's no driving for 1 year period. So if you're dealing with the DUI in Georgia, don't guess your way through these decisions. Even if you don't hire me, talk to someone who handles DUI cases regularly, because decisions you make early can follow you for years. If you want more straight answers about DUI law or personal injury law, subscribe, send us a comment. We'll be glad to help you out.